Yeah, thank you. We have our next speaker, Jayce Allen. Hopefully, I'm pronouncing your name correctly. And so, Jayce, take over.
Can you see me and hear me?
Yeah, we can see you and hear you. Thank you.
Okay, let me see if I can bring up my presentation. Bear with me. Share. All right. Is that coming up? Because I don't
Yep.
think I'm seeing, are you getting the proper?
Yes,
There
yes,
we go.
we can see everything. The PowerPoint, we can see you, we can hear you.
All right, it's go time. Well, thanks so much for having me. You did pronounce my name correctly. It is Jayce Allen. I am the current Drug Treatment Court of Vancouver Crown Counsel. This is my third time in this role. I came back to this role last September. And I'll start, my presentation is going to deviate a little bit. I took the assignment down a different path, I think, than most. I'll start with an overview of our program. And having just listened to Judge Orr's presentation, our program is very, very similar. And I think a lot of the DTCs are. So I'm not going to get into the nitty gritty. I'll just say that we are both federally and provincially funded, and the requirements of that federal funding give us certain parameters within which we have to work. We require a guilty plea, no violence. Jurisdictionally, we cover the whole province, but the treatment center is located in Vancouver, and at present, we do require participants to relocate to Vancouver. We don't have the capacity to offer the treatment program remotely. It's a 4-phase program that requires, in the beginning, daily attendance at our treatment center, and then that contact diminishes over time. It's a minimum of 14 months, and it takes, on average, between about 18 months to 2 years. And then all graduates receive the same sentence, which is a suspended sentence with 1 day of probation, no conditions. So we're very fortunate. We have 5 agencies at the table in our program. The court team is, of course, comprised of a dedicated judge and 1 backup judge. 1 full-time Crown, that's me. I'm with the PPSC. We do accept provincial charges. We simply take conduct of those. And we have a dedicated legal aid lawyer for all our participants. Our case management is provided by BC Corrections probation officers, and they work very closely with our health services provider, which is Vancouver Coastal Health. And Vancouver Coastal employs addictions counselors. They have a medical doctor who specializes in addictions medicine, and a nurse practitioner. We are very fortunate to have a large outpatient facility that houses the entire probation and treatment team. And in there's a number of rooms where counselors can run groups, conduct one-to-one therapy. They'll even host extracurricular events like drum circles, which are a lot of fun. And they'll celebrate various events for the participants. They also do the witness urine screens on site. So, I guess I should have gone to that first. There's all our agencies. So I want to talk about the current landscape, because our program, like many other programs, are facing a lot of external challenges. And what we're doing isn't working anymore because the people we're serving are different, or they're not coming to us in the same numbers they were before. And that's by no means a criticism of the work we've done so far. But we now have so much more evidence and information about addictions than when this program started in 2002. The Drug Treatment Court of Vancouver was the 2nd in the country, behind only Toronto. And at one point we were the largest, not anymore. But we have so much more understanding and information available to us to inform how we handle our participants. So I chose to focus my presentation on identifying some of these challenges we're facing, put some ideas forward to explore possible ways to address these. These are by no means the only ways. And I really want to invite anybody watching this to think about some of these alternatives. I think we should look to some other fields of study to find ways to further support our clients, maybe add some new supports. I'll give some examples later, and to augment the program's best practices that we're already employing. So the biggest challenge for us, and again, probably many programs, is diminishing enrollment. And in BC, we have a rather unique, perfect storm of factors that are contributing to our low numbers. The changing political and legal landscapes have contributed to reducing the appeal of what was once the only way someone had of getting around the mandatory minimum jail sentences for PPT and trafficking involving fentanyl. So I don't know how well known the Ellis decision is outside of BC, but it's a BC Court of Appeal decision just from last summer. It's out of, well, the provincial judgment was out of Campbell River, and Tanya Ellis was initially sentenced to a suspended sentence with 12 months of probation. The decision was successfully appealed by the Crown to the Court of Appeal, but it still resulted in a non-custodial sentence. The Court of Appeal imposed a new sentence, extended Tanya's sentence to 3 years of probation with more strict conditions, but it really propped open the door to non-custodial sentences and encouraged courts to place considerable emphasis on the personal characteristics and circumstances of substance users who commit crime in order to access their needed drug. So the second factor is we have some other therapeutic courts in BC, which is a wonderful thing, but of course they compete with us for our participants. We have First Nations Court and also the Downtown Community Court, which you will hear about from Sharon Lockhart right after my presentation. And those courts offer intensive wraparound programs that really support their participants to healthier lifestyles. There's also a PPSC pilot project that decriminalizes 2.5 grams of hard drugs. And that, of course, has resulted in fewer charges that would have qualified for our program even being approved. And it's already been a few years since the PPSC charged simple possession, but some of the quantities that are caught by this new initiative, excuse me, of say 2.5 grams might have resulted in PPT charges if it's a particularly potent drug. And lastly, we have new initiatives in restorative justice and alternative measures where some of the files that would have been referred to us are going through those processes. So if we are going to appeal to applicants, we have to change what we have to offer. There's no drug treatment court without participants. And if we're going to attract them, we have to offer them something they can't get elsewhere. And I would say the focus is on two things. First, we have to offer an appealing sentence alternative or bail pending sentence, an appealing program to what they can get in regular court. And second, if they are going to come into our drug treatment court program, we have to offer them a real chance of success. So what do we define as success in drug treatment court? And I think with all the changes that are happening around our programs, there's a really disconcerting state of flux and uncertainty. But there's also an opportunity to re-examine the components of our programs, keep what works and jettison what doesn't. So what I hope to do is share with you some of our challenges and offer up some ideas to stimulate your thinking and encourage discussion of the therapeutic courts in our country. So I came up with 3 possible options. What are some things we can do to affect a different result? Can we improve our screening processes? Can we really stay true to an evidence-based approach versus an ideological one? And the hardest question, can we improve contingency management? So like other drug treatment courts, the screening process is very similar. The Crown focuses on what is the offense and the criminal history. Corrections focuses on whether the person can be safely supervised in the community, and the health partner focuses on whether or not there's a current active addiction. Those are the screening criteria. How can we do it a bit differently? Well, as a Crown, I know that our office is starting to consider on a case-by-case basis more serious offenses. What we're finding is that as we get more sophisticated and the criminal justice system does, so do offenders. And so what we're finding now is the people we want to target, the unsophisticated offenders who have serious drug addictions, are now being recruited by sophisticated predatory criminals into situations that put them in a lot of legal jeopardy. We're finding people carrying large amounts of drugs on them or being found in meth labs that have weapons and lots of money and lots of drugs in them. Offenses that would normally attract that understanding that they are doing this for commercial profit, and that would normally put them outside of the eligibility criteria for our program. Secondly, corrections or probation can hopefully refine tools to be able to better predict who is a safety risk for the treatment team. I think sometimes using the criminal history and saying there's a violent offense on there might not be the most accurate tool. And thirdly, if we can expand our screening criteria from the health perspective, so that we don't end up with people who've gamed the system by simply giving the right answers during their treatment interview. Again, I don't have all the answers. This is just to stimulate thought and conversation. So this is just more of what I was just talking about. Evidence versus ideology. I know that all of the programs the drug treatment courts and other therapeutic courts employ are evidence-based. But is that enough? We take pride in that, but are we collecting and analyzing our own data along the way to ensure we're achieving the results that the evidence-based program did? And can we assure ourselves that treatment and court directives are having the desired outcomes on a day-to-day basis? How do we know? What data points do we collect? How do we analyze it? And what do we do with it? So I want to stress the importance of data in tailoring treatment to the individual for the greatest possible effectiveness. There's no point in calling an approach evidence-based if you're not taking the same kinds of data that the study that produced the evidence did, and which demonstrates you're getting the same results. We need to track fidelity to the evidence-based model we're adopting, as well as the effects it's having on participants. Data collection on all points of intervention is key to customizing treatment. And we have to regularly review that data so that we can be agile in choosing next steps for our participants. If we have a recommendation to impose a sanction for, say, a missed group during the week, there should be a hypothesis that accompanies that recommendation. In its simplest form, the theory is that imposing a punishment on a participant will change their behavior in a specific way in the future. Practically said, if the participant is assigned an essay on the importance of attending group therapy, and the intention is that this contingency will result in improved attendance in future, then tracking that is necessary. And failure to do so is not only a lost opportunity to maximize treatment, it's also evidence that the program is ideological, and the failure of a participant to behave in accordance with that ideology results in punishment that doesn't serve any practical purpose other than to further ingrain that the locus of power is not with that participant. So data science is no easy field. I don't suggest that we try to come up with this ourselves within programs, lawyers, counselors. We need comprehensive metrics that demonstrate what we're doing is working. I know my level of understanding of data analytics is rudimentary at best, but there are people out there who do this professionally. And my suggestion is to recruit academics and professionals who appreciate the significance of data in steering a program towards success and who have the expertise to design functional tools. What comes to my mind is looking to the field of behavior science. They can help case management professionals customize programming and evaluate day-to-day impact of both court and therapeutic measures. So all members of the drug treatment court team participate in behavioral procedures intended to steer participants towards healthier lifestyles and pro-social habits. Our programs provide counseling, group therapy, education, opportunities for peer support, sometimes recreation and fun. But the most notorious procedure, the one the court program is most known for, is contingency management. So drug treatment courts operate on the rudimentary principles of behavior modification, reinforcement, and punishment. And criminal courts have historically been in the business of the latter. More recently, therapeutic courts have seen benefits and improved outcomes associated with adopting contingency management procedures using both consequences. And there's a lot of room for exploration of reinforcement over punishment. Sanctions are familiar territory, but we know the evidence demonstrates these are far less effective at facilitating behavior change than rewards are. The temptation to rely on the court as the enforcer is strong, but we have an opportunity to leverage our relationships with participants to incentivize pro-social behavior. There's also a cost to favoring punishment over reinforcement. Damaged therapeutic relationships, furthering participant trauma, and entrenching shame, none of which are likely to lead to our goals. As I said earlier, if a proposed sanction isn't accompanied by a hypothesis that attaches to an outcome, then we are simply exerting power over the powerless. At worst, it demoralizes a participant, contributes to a critical self-perception, and derails their progress. At best, it may contribute to their compliance with program expectations and maybe even contribute to the ultimate goal of graduation. If the sanction results in the former, we should stop doing it. In the latter, then we need to examine why closely so we can use that tool deliberately and with precision. How am I doing for time? Okay. So one of the other things I want to bring up is that all of our participants are not equal. We all know this. But one of the things that has become clear to me is that there's a real variation in executive functioning. So we view participants as autonomous adults with a choice to comply or not comply. Failure to comply is defiant, and we implement something corrective. We also say that in the name of accountability, we have to justify punishment sometimes. But there are clients who don't have that choice. What's being asked of them is simply beyond their executive functioning ability. It's important to note that we have a lot of undiagnosed neurological conditions in our population: autism, ADHD, brain injury, trauma. Their motivation is different, and our treatment should account for it. One of the tools that we use in behavior analysis is something called a task analysis. It's where we can teach somebody how to do something. It's an adjunct to an addiction treatment that might support success. And I'll give you an example. So this might be two different clients, and the task is that we want them to attend group. So for the more sophisticated client on the left, it's a simple 7-step procedure. For somebody who's got a lower executive functioning ability, it might be a 16-step or more procedure. And for someone to sit down with them and to write this out and go over it with them and teach them would probably improve their chances of attending group. So I've blasted through a lot of information. I hope I've stimulated some thought, and I'm happy to continue a discussion on any of these things or more. But I do think there's hope for the future of our programs. I know it's a challenging time, but I believe we're up to the task of adapting.
Yeah, wow. Jayce, thank you. What we could do is